Hello, everyone, and thanks for being here. As many of us expected, the Supreme Court's refusal to review bans on so-called assault weapons and high-capacity magazines has sent a very clear signal, one that's now being seized upon by states that are determined to strip away the rights of lawful gun owners. Now that these states believe they've essentially been given the green light, we're already seeing a surge in new firearm restrictions. One of the most recent and alarming examples comes out of Rhode Island. This state was one of the two where a challenge to their magazine ban was denied by the U.S. Supreme Court. Feeling empowered by that decision, lawmakers there are now moving forward with a sweeping new gun control bill, H5436 Substitute A, also known as the Rhode Island Assault Weapon Ban Act of 2025. Yes, you heard that right. Rhode Island is wasting no time. The bill has already passed out of the House, and it sets the stage for some of the most aggressive firearm restrictions we've seen yet. Now, I have a feeling this is just the beginning. We're likely going to be talking about many more of these bills in the coming months. And while they may vary from state to state, the trend is clear. More bans, more restrictions, and fewer rights for lawful gun owners. From assault weapon bans to magazine limits, even bans on specific models like Glocks, these proposals are popping up fast. Why? Because these states believe the Supreme Court won't intervene. So today we're going to take a closer look at what exactly Rhode Island's new bill says. I'll break it down into three key questions that I know many of you are already asking. 1. What does this bill actually ban? 2. When would the law go into effect? 3. And what happens to firearms that people already own? Let's start with what the bill would ban. According to the language of the legislation, Rhode Island would redefine a wide range of commonly owned firearms as assault weapons. This includes semi-automatic shotguns with a fixed magazine holding more than 6 rounds, and semi-automatic shotguns capable of accepting a detachable magazine and equipped with any one of the following features. A folding or telescoping stock O, a pistol grip or thumbhole stock O, any accessory or modification that acts as a forward grip held by the non-trigger hand. The bill also outlines 2 new classes of rifles that would be classified as assault weapons under state law. Any semi-automatic rifle with a fixed magazine that holds more than 10 rounds. Any semi-automatic rifle capable of accepting a detachable magazine and having any one of the following features. A folding or telescoping stock O, a grenade launcher O, a barrel shroud, or any feature that allows the user to hold the barrel without being burned O, a pistol grip or thumbhole stock O, a flash suppressor O, a threaded barrel. These are features found on thousands, if not millions, of firearms legally owned by Americans across the country. And now, under this bill, any firearm meeting these criteria would be considered banned in Rhode Island. Now that we've covered which types of weapons are being banned, let's talk about what activities are also criminalized under this legislation. This is where things get even more serious. Starting July 1st, 2026, unless an exception applies, it will be illegal for anyone in Rhode Island to manufacture, sell, offer to sell, transfer, purchase, possess, or have under their control any firearm classified as an assault weapon under this law. And this isn't just a slap on the wrist. Violating this law comes with a penalty of up to 10 years in prison, a fine of up to $10,000, or both. That's a felony-level punishment for owning something you may have lawfully purchased years ago. Now here's the big question. If you already own one of these firearms, will you be forced to give it up? The answer is no, provided you comply with some strict conditions. You will be allowed to keep your firearm, but only if you register it with the state and obtain what they're calling a certificate of possession. Yes, not only is this bill banning entire categories of firearms that are in common use, but it also establishes a state-run registry, no matter how much they try to claim otherwise. Let's look at how this process works. Between now and July 1st, 2026, anyone who owns one of these newly banned firearms, assuming they are legally eligible to possess a firearm, can apply for a voluntary certificate of possession. This application must be submitted either to the Rhode Island State Police or the local police department where the individual resides. If you own multiple firearms that fall under this new classification, you'll have to submit separate applications for each one. Now, even though lawmakers are claiming this won't create a registry, let's examine exactly what information the state will collect as part of this application. A complete description of the firearm, including make, model, and serial number. For firearms manufactured before 1968, other identifying marks may be used in place of a serial number. Your full name, home address, and date of birth. Any additional information the state deems appropriate. Each application must be signed by the applicant, and that signature certifies that all the information provided is accurate. Oh, and let's not forget, there's also a $50 application fee for each certificate. So not only are Rhode Island residents being told what they can and cannot own, they're also being asked to pay a fee and hand over detailed personal information to the state in order to legally keep something they already own. So here's the reality, Rhode Island. If this bill becomes law, you're going to be forced to pay the state just to keep property you legally purchased and have legally owned for years. That's what it comes down to, a fee for your rights. But that's not all. Even if you comply with the law, register your firearm, and get your certificate of possession, don't assume you'll be free to use that firearm as you choose. This bill severely limits where you can legally possess and operate these grandfathered firearms. According to the language in the legislation, once you register an assault weapon, you're only allowed to possess it in specific places. 1. At your residence, business, or other property you own, but even then it must be stored securely. 2. At a licensed target range, one that holds the proper business or regulatory license for shooting activities. 3. At a licensed shooting club, provided it's properly authorized. 4. During exhibitions or educational events related to firearms, but only if those events are sponsored by law enforcement agencies, national Second Amendment organizations, or similar groups. 5. While transporting the firearm to a federally licensed firearms dealer, but strictly for service or repair. 6. While traveling directly between any of the permitted locations mentioned above, nothing more, nothing less. That's it. Step outside those narrow boundaries, even with a lawfully registered firearm, and you risk serious consequences, up to 3 years in jail and a $2,500 fine. Rhode Island, this bill, H5436 Substitute A, is not some hypothetical proposal. It has already passed out of the House. It's halfway to becoming law. If you're not paying attention now, by the time it lands on the governor's desk, it may be too late. And what's worse, this isn't just about Rhode Island. Unfortunately, you're likely the first in a wave of states preparing to push even harder on these restrictions. We're entering a phase where more states will attempt to expand bans on firearms and components that are commonly owned and lawfully used by millions of Americans. Why is this happening? Because the U.S. Supreme Court has consistently refused to intervene. They declined to hear Snope v. Brown, which challenged an assault weapons ban. They also denied Ocean State Tactical v. Rhode Island, a case that challenged Rhode Island's magazine ban. Most recently, on June 6th, the court dismissed Hansen v. District of Columbia, another challenge, this one to D.C.'s magazine ban. Each time, they simply let the ban stand. That silence from the court is being taken as permission. And now, other state legislatures are following suit. They're emboldened, and they're not hiding it. Rhode Island is simply the next in line, but not the last. If you want to review this yourself, the bill is H5436 Substitute A. We'll include the official link below so you can read every word for yourself. And honestly, Rhode Island, if you're thinking about what to do next, you may want to prepare now, while you still legally can. If you have any questions about this bill or anything else related to your rights under the Second Amendment, feel free to reach out. Our contact information is in the description box. Got an idea for a video topic? Let us know by clicking the suggestion link down below. You can also subscribe to our monthly newsletter for updates on new laws and your rights as a gun owner. And finally, and most importantly, remember this. Being a lawful and responsible gun owner means understanding the law, knowing your rights, and being prepared to protect them. Thanks for watching. Stay informed, stay alert, and above all, stay safe.